My name is Lloyd Bell. I'm a trial attorney from Atlanta, Georgia. My firm is Bell Law Firm. We focus on medical malpractice almost exclusively.
How long have you been practicing?
Almost 30 years now.
What would you say is the greatest source of experience, right? Valuable experience for you, over the course of your career?
The greatest source of experience has been jury trials, and then the opportunity to talk to juries after the trial is over. And that's where you learn the things that you thought you were doing that were brilliant, the jury was not as impressed with, and the things that you didn't even appreciate you were doing correctly, the jury understands and values those things, and that helps a lot. Plus, being able to talk to a jury and understand how the story process unfolds and what they connect with in your client's case. Very rewarding, very helpful.
Trial it's one word that describes a whole lot of stuff, right? And what was it like for you at the beginning when you had to wrap your brain around what it meant to get through an entire jury trial?
When I first started practicing and doing jury trials, I didn't know what to do. So I tried to imitate what I saw on TV or what I saw other successful older lawyers doing. And I wasn't myself, so I acted aggressively and I acted like Perry Mason, and I huffed and puffed around the stage. And it didn't feel good when I was doing it. It didn't feel authentic, and it usually did not connect with the jury. So it took many years of trial and error to understand that the most powerful place you can be in trial is when you are your authentic self and not trying to be somebody else. But whether that's good or bad depends on who you are, but the ability to tell the story and the truth of the story from your authentic self was something I wish I had known sooner.
If you're a lawyer and you want to learn, there's a lot of ways to learn now. What was it like when you were young and you were starting out? What were the sources of learning and education that you had back then? And how do you think things have changed from your experience in terms of learning and becoming better?
Well, things have changed so much from how it was when I was starting off about 30 years ago. We're in the golden age of education. There are more lawyers giving their time and energy to teach the next generation. And that just didn't exist when I was coming along. So you had to be creative to find ways to learn from the more senior and experienced attorneys. Back when I was starting off, it was very rare to have a jury trial televised or videotaped. And we used to use these things called VHS slides and VHS tapes. So I would try to find trials that had been videotaped and then get a copy of the VHS tapes and watch them. And I had a chance to watch some wonderful lawyers that way, but it took some effort to get those tapes because it wasn't like there's no internet back then for us, and very few seminars of this quality where people come and share their opportunities and experiences. So it was a very different world than it is today. The Trial Lawyers University is incredibly valuable because it brings together a lot of trial lawyers from different experiences and backgrounds. And trial lawyers, almost more than any other group of professionals, love to talk, and they love to share, and they love to tell war stories, and that's how you learn. You don't want to make a mistake when a client's life is at stake and their future's at stake. So if you can talk to another attorney who's had your kind of a case, even if you just pick up one or two little nuggets of information, it can make all the difference. So I think Trial Lawyers University has done a very good job of bringing together a lot of talented people, but also a lot of generous and collaborative people who are willing to share.
What would you say to trial lawyers out there? What do you believe that an attorney should be accomplishing or hoping to accomplish in jury selection?
Well, there are a number of things attorneys should try and accomplish in jury selection, but they also have to know there are limitations to what you can accomplish in jury selection. There are a lot of people teaching jury selection and really give the impression that you can do more and accomplish more than you in reality can. And what I mean by that is you just do not have the opportunity to get to know people at the deep level to make truly informed decisions that this juror is the best juror and this one is not. So a lot of times you have to rely on your instinct and your gut, but most importantly with jury selection, you should be focusing on collecting data, actually listening to what they tell you. Because people will tell you, they'll answer your questions, they'll tell you information about themselves to help inform your decision. But the school of thought of I'm going to get there and I'm going to be charming and I might tell a sports joke or two and make good eye contact and mirror the jurors and they'll like me and we'll form a tribe together and we'll, all be bonded, I think is overly optimistic and unrealistic. What I teach people about jury selection is they need to focus on the data. Listen to what people are telling you. Talk to people from an authentic, honest place and ask them questions and ask them to reveal about themselves the information in the background that might inform their decision-making process. But don't put too much hope in your own personal charm and good looks and ability to get people to like you. Focus more on doing the job. And the job is to get information about this group of folks so that you can make informed decisions of the people who are best suited to listen to this particular trial.
And I like that last point, right, in terms of this particular trial. You can't go into jury selection in this case the same way you went into jury selection for that case. How should a trial attorney be adjusting from case to case to choose the right jury for that particular case?
Well, it depends on the type of case. It starts with the case you're trying. Is it a medical malpractice case? That's mostly what I do. And in medical malpractice cases, those have their own unique factors that impact the jury. People like their doctors for the most part. People have a positive view towards healthcare professionals. But everybody interacts with the healthcare environment, either directly or they will eventually, or have a family member who has. So people have very strong views about healthcare. So if you're dealing with a medical malpractice case, you have to spend a lot of time talking to them about their experiences in healthcare, good and bad. We always ask the question of jurors, how many people feel gratitude towards healthcare professionals? And a lot of people will raise their hands and say, well, I had a great experience with my doctors and they took care of me and they listened and they responded to me. They may sound like a quote, bad juror that you may not want on your case, but it could just be the opposite, that's a very good juror because they understand what good medicine looks like and they're going to be less tolerant when they learn about the bad medicine that brought them to trial.
Let's go into opening statements. What should trial attorneys be hoping or looking to accomplish in an opening statement?
Well, there are a number of goals in opening statement that you hope to accomplish. First of all, you want to set up the framework for the case so that the jury understands the core components they're going to need to receive the evidence and make a decision. So in a medical malpractice case, for example, there are certain components the jury has to know. They have to understand some basic medicine, so you have to have a teaching component in opening statement. But more importantly, or equally importantly, they have to understand the sequence of events that led to this bad outcome. And you talked about how you were taught not to argue an opening, and I would agree with that. But the word argument can have some various meanings. What you're trying to accomplish in opening is you're trying to tell the story of the case in a non-advocacy way. You don't want to start off, this is a case about gross misjustice or gross dereliction of medical judgment. All that advocacy needs to be set aside. Instead, you want to adopt the persona of a teacher that is delivering information in an incredible way. And you do that by speaking like a human being, jettisoning, getting rid of big words like jettisoning, but not talk about, demystify the medicine. So for example, in a stroke case, we had a stroke case just last week that went to trial and went to verdict. The medicines can be very complicated. You're talking about thrombolytics, you're talking about thrombectomy, all these big terms. But instead, when you bring a prop in opening, we brought a bottle of liquid Drano and said, this is TPA clot buster. Hold up a bottle of liquid Drano. Chemical goes in, dissolves the clot. This is a snake you use to clear out a clot in your sink. This is all a thrombectomy is. It's a device that goes up in the blood vessel, snatches the clot, and pulls it away. So one of the goals of opening statement is to demystify the medicine, give the jury's confidence that they can understand this and be in a position to make a judgment against a doctor or hospital, nurse, whoever the defendant is.
Aren't you also endearing yourself to the juror by taking the role of teacher? You know, it's like, look, I'm here. I'm going to be of service to you as a teacher, right? I'm going to share with you the medicine with the hope of you understanding it, so that you'll be more informed. Does it ever work in that way in terms of outcomes, perhaps?
Well, it's helpful to think of the role of a teacher when you're presenting in the case, because what do teachers do? Teachers explain. Teachers use illustrations. They use models. They may use their own body to point to different parts of their body to explain things. So the teacher analogy is helpful, but it's not the whole piece. I mean, we have a job, and they know we're advocates. The jury knows we have an agenda and that we're there to convince them of something. So juries start off highly skeptical. The primary role that a lawyer has in opening is to be honest, credible truth teller. We have to be 100% scrupulous in delivering the evidence. If we hide something or shade something inaccurately, the jury will punish you, and of course, by extension, your client. So we have to be scrupulously honest with the jury. And we talk about that with the jury. We tell them, we promise them that if you find us saying something or doing something at all misleading, hold it against us. We plant that flag in the ground, and we say, we're going to bring you the truth. We're going to bring you this case, and you're going to learn the evidence and the facts that demand a verdict in favor of our client.
How much do you talk about, how much would you say an attorney should talk about the defense's strong points?
There is a variety of opinion on how much you should address the defense strong points in opening statement. One conventional wisdom is that you should try and defang the defenses by identifying each of the defenses and sort of putting your spin on it, and sneaking up on it maybe and saying, well, before we could come to court, we had to learn some things. Well, those things are the defenses, and it's a little flat, it's a little misleading, a little inauthentic. I don't believe you should elevate the defenses in your opening statement, because once you give oxygen to their defenses, the jury elevates them in their mind. Oh, this must be important because the plaintiff's lawyer brought it out. I subscribe to a different view, which is I call the endorsement view, which is if you identify and discuss the defenses, then you're giving them too much credence. So I don't talk about them. I talk about our case and what's the strengths of our case, the story of our case in an authentic way. Jury knows the defense is going to have a different position. The defense can bring up their points, and we'll address them in the evidence through cross-examination. But I'm not going to elevate their defenses in my opening statement and give them any credibility.
All right, let's jump into direct, right? There's, again here, tons of theories, tons of ideas of how to approach a direct examination, the order of witnesses. What should attorneys be looking to accomplish in the presentation of their case, maybe in the direct examination of their witnesses?
The most important thing for attorneys to do in direct examination is the most difficult thing, and that is to shut up and get out of the way. Because attorneys love to talk, and they love to control. It's just in our nature. We have to have those qualities to develop the evidence and to do our job to some extent. But those talents or those abilities don't serve us well in direct examination. They get in the way of the witness. So the witness, your job as the attorney is to facilitate the witness's communication with the jury. And you do that with open questions. You don't plant yourself to be the center of attention, because you want the conversation to be between the witness and the jury, and for the jury to feel that connection. A lot of lawyers will make the mistake of every time the witness starts on a narrative and discussing some point of their testimony, the lawyer will jump in and like, wait, Before we go there, I've got an outline. I want to cover my points, and the juries get so frustrated with that. It's like, man, just be quiet. Let the witness talk so I can hear the witness and evaluate the testimony myself.
And I know this just from asking, conducting these interviews, right? Somebody was saying, our makeup artist was saying, you don't write anything down, and I don't come in with a whole big list of questions that I've thought of, because I want the questions that I ask to build one upon the other, and to allow the story to come out that way. I think when you have a plan and you stick too closely to it, you end up robbing yourself of something. Do you think that's true in direct examination?
I think that's exactly true, that you need a plan, but you have to have the flexibility to set the plan aside. So the way I like to explain it to younger lawyers is that you prepare for trial with extreme effort and diligence, and develop your outlines, your written outlines. You outline and draft your opening statement, your closing argument. You do all those things ahead of time so that when you get to trial, you have the freedom to be flexible. You can adapt to changing circumstances, and they always change. A witness will say something or do something that's completely unexpected, and you have to have the flexibility to be able to pivot and respond to it. You can't do that if you're living inside your outline. You have to be present, you have to be listening to what the witness says, and you have to have the instinct to capture what they say. And what I'll typically do is write it on a flip chart so that we can refer back to it later and close an argument. But I completely agree. You need that level of diligence to prepare, but you have to have that confidence to use improvisation in response to changing circumstances.
Let's talk about order of witness and presentation of evidence. What should they know about that?
Well, the order of witness and presentation of evidence needs to be intentional, and it needs to be goal-focused, because what we're doing as trial lawyers in court is we are putting on a production. We are putting on a show to some extent. And just like a director has to decide which scenes to introduce first, when to introduce the actor, the dialogue, the props, all those elements that go into a production, we have to be thinking the same way as lawyers. So it's extremely important how you start off the show, how you start off the trial. You want to grip the audience. I teach this in a number of classes. I call it the Netflix opening. You want to start your trial, your opening, with a compelling scene. You want to do the same thing with witness testimony. You want to start off with a witness that is compelling for some reason. Now, it might be the defendant doctor who you call for cross-examination, or it may be a particularly impactful expert witness, or it may be a corporate representative of the hospital that you call for cross-examination. But that first witness has to grip the jury, and then from that witness, the story has to build until there's a crescendo, a climax, and then there have to be witnesses that give the jury what they need to be motivated to reach a powerful verdict when the case is over. So it's very intentional. You can't just slot witnesses in based on their schedules. I mean, sometimes you don't have a choice, but in the age of Zoom, where we're now using Zoom witnesses to come in to help smooth over the rough edges of scheduling, there's really no excuse for not sequencing the witnesses that present the most compelling story.
And what about evidence? Are you looking at evidence the same way in terms of starting off with the presentation of something that's some piece of evidence that's compelling, and perhaps I would imagine you're using the witness and the evidence together to tell that particular compelling aspect of the story.
In medical malpractice cases, the type of evidence you're dealing with is mostly medical records. Even though you might have thousands of pages of medical records, they're usually about 5 or 10 documents that really matter. So we do use those. I use a lot of electronic tools to present evidence, so I can do it wirelessly and pull up exhibits for the jury to look at, for the witness to look at, and then circle with highlighters and call-outs and interact with the evidence. And the reason we do that is because the jury comes into a medical malpractice case and they ask themselves, well, how can I judge doctors? I mean, they've been to medical school and they've got all this education. So our job as the trial attorneys is to demystify the medicine and to simplify it And we do that with physical evidence that, this isn't complicated. This is a doctor who didn't show up to see the patient, and here's the records. This is how to read the record, and we point out the different parts of the medical record. So the physical evidence is very important. The human evidence, the witness testimony, is the most important because that's where the jury is making the credibility determinations as to who should they believe, who's telling me the truth. Because juries want to get it right. I mean, these are people that have been snatched out of their homes and lives and forced to show up in a courtroom to participate in a civil duty that's not going to increase their pocketbook or benefit them on the surface, but they want to get it right. So we have a responsibility to show them the best evidence, present all the evidence, and that's what we try to do.
All right, let's jump into cross. I know some attorneys that they just love cross-examination. Right. And then some people really love cross-examining a defense expert. Like that's just their thing, eviscerating a defense expert. But from a broader standpoint, right, what should attorneys be looking to accomplish in the cross-examination of witnesses?
So much of it depends on who the witness is you're crossing. So if you're crossing a professional defense testifying expert, a frequent flyer who's testified 1,000 times, 99% of the time for the defense, that kind of witness lends themselves to a more aggressive cross-examination for bias and an improper motive. Now, there are other witnesses who are also adverse to you that might receive a different type of cross, a softer cross, such as a defendant doctor. A defendant doctor goofed up and caused a horrible outcome, but the doctor doesn't come across as a villain. He or she may not admit liability. They may say they didn't do anything wrong, but if they're well prepared, they're going to present themselves pretty sympathetically. So with that kind of witness, I use a softer approach, more of a gentle, factual-driven basis, and show some compassion. And this is something that younger lawyers don't necessarily know coming out of the box, that you don't have to be the tough person, lawyer, trying to beat somebody into submission. In fact, that's almost always the wrong move. Even the aggressive cross-examinations, it can be done with respect and showing dignity to the witness. Jurors resent lawyers who try and humiliate people because they see us as a more powerful position than a witness, no matter how sophisticated the witness is. And nobody likes a bully. And they see a lawyer trying to bully a witness, push him around, show who's smarter, who's tougher, who's in control. It almost always goes badly for the lawyer. Much better place to be is to approach the witness from a place of respect and dignity, but then carefully reveal the points where the witness starts revealing their true colors and reveals themselves rather than you attacking. So that's very important in cross-examination.
Closing is most like what you see on TV, right?
That's the good stuff.
It's the good stuff. What sort of primary goals should a trial attorney have in going into closing? What should they be looking to accomplish?
There are a number of important goals in closing argument. Whereas opening is the story of the case, closing is the story of the trial. So by the time we get to closing argument, we've all had a common experience. We've had an experience with the jury. And we talk to the jury. It's like, what have we learned? Because we're part of the jury in my mind. That's how I look at it. What have we learned in this case? And you have to accomplish a few things. Number one is you remind the jury of what the evidence has been so that you can help arm your favorable jurors with sound bites, talking points that they can take with them back to jury selection and advocate on your behalf. So you're not generally going to convince anybody in closing. People have, for the most part, made up their mind, not firmly necessarily, but they have a general sense of who they want to win at this point. Your job as the advocate is to give your advocates on the jury the tools and the sound bites and the motivation to go back and fight for you. So that's one goal. And another extremely important goal in closing is, of course, to motivate the jury to return a verdict that includes sufficient compensation for your client. So you have a number of different notes to hit. One note is the teacher note. One note is the math teacher part, where you have to teach the economic damages, the future economic damages. So you're more of it's a little drier point. And then there's another note that you have to hit in closing, which is the righteousness, the passion, the why are we here, what's the motivating factors that are going to get the jury to be like, yes, we have to do something. We've got the power to do something. It's a lot of different emotional levels that you have to touch on to get to the point where you're handing the jury the case, you're trusting them with the case, and you want them to feel privileged to be able to deliver justice to somebody who's been horribly injured. It's a lot to accomplish, and I use outside people to scrutinize my closings and to help me develop them. And I encourage lawyers to do that too, because it is such an important part of the trial, and you really need to stick it correctly to give your case the best chance for success.
Jury instructions are typically an important part of the closing of a case, right? How do you interact with jury instructions in your closing, if that's where you interact with them? I'm assuming you do. And also, I'll just ask the question while we're here, general damages. How do you communicate to inform the jury of the general damages that are deserved in a case? So jury instructions and general damages in closing.
Sure. One important thing to teach in closing argument are the jury instructions, the law that the judge will give the jurors to decide the case. Because the jury is sort of like the back of the Monopoly game where all the rules are. And the jury wants to do their job correctly. It's almost a universal truth. And the rules for deciding the case are the jury charges. So what I'll do is I will use a slide deck in closing. I use Keynote or PowerPoint type presentation, and I'll put the actual charge up on the slide, and I'll talk about it. And I'll talk about it in context with the evidence, because the jury instructions give a basic skeleton for how the jury should decide the case. It starts with liability instructions, causation, and damages. So I want the jury to hear the law that the judge gives them and remember how I taught it and how it relates to the evidence. So very important to do that in the case, because you don't want the defense to own the jury instructions and have that benefit when the jury goes back to deliberate. Another critically important point of a trial is how to present general damages in closing argument. General damages are also known as non-economic damages or pain and suffering damages. I like to call them human damages or quality of life damages. And those are the damages that matter the most. And one thing I'll often argue to the jury is that we've heard a lot of expert testimony from doctors and nurses and economists, but you are the experts in the general damages. You are the experts, you 12 people are the experts on what it means to lose the ability to hold a child, or to throw a baseball to your son, or to go to your daughter's first recital. And you know from your experience what the value of those things are. You can't put a price tag on those in the normal world. You can't go to the store and buy, I'll have one Saturday football game with my son and buy that. You can't do that. But you as the jury are asked to do that and directed to do that by the jury instructions. You have to put a price on these things, these diamonds in the life of the plaintiff, and decide how much money it will take to make up for those things that have been taken from the plaintiff. So I speak in those terms. I'll talk about my own personal experiences, the things in my life that give me value, so the jury can understand and have some context for general damages. But the most important thing about general damages is that the jury understand that they are required and that there is a way to approach them. And there's a lot of different sort of conceptual ways that we have to help the jury understand how to put dollars to pain and suffering. That's a very challenging part of the trial, incredibly important part of closing argument, to address that in a robust, meaningful way that will motivate the jury.
The last question is really about attorneys getting better and learning more. Why is it important that trial lawyers just continue to study and get better and seek out new ways to improve as it relates to the service that they're providing, the representation they're providing to their clients?
It's incredibly important for lawyers to realize that they are committing themselves to a lifetime of learning that's necessary to represent their clients. We're law students for the 3 years we're in law school, and we are law students until we stop practicing law, because you always have to be learning new ways to do things. Of course, Court of Appeals is constantly putting out new decisions. So there's the substantive part of law that you have to pay attention to and stay abreast of. But there's also the techniques and the human developments, the way people think, the way people decide disputes. So you have to learn the social sciences, and you have to learn from each other. The most dangerous lawyer is one that thinks they know it all. So there's an element of humility. You have to stay humble, and it's because as soon as you start believing that you've got it figured out, or you have a few good verdicts under your belt, that you've got the magic sauce to get these great results, that's where your client is most in danger, because chances are you'll fall on your face at the next trial. So you have to stay humble. Don't presume that a lawyer who's only been out 3 or 4 years that may be offering some piece of advice should be discarded because, well, who do they think they are? You can learn great things from younger people. You can learn great things from older people, or more experienced, less experienced, because every human being has their own unique experience. And at the bottom line of what we do, it's a human endeavor. We are trying to help individual human beings. We're trying to convince other human beings. And through this process, we're trying to become better human beings ourselves. And that's really the beauty of what we do.